Hello friends, today we are going to have a overlook on recent judgment and order passed by Honorable Supreme Court of India in the matter of Javed Ghulam Nabi Sheikh versus the state of Maharashtra and another. In this present matter, the Honorable Supreme Court of India has granted bail to the present appellant and thereby observed that if the state or the any other prosecution agency including courts could not secure the right of accused to provide speedy trial as enshrined under Article 21 of Constitution, then they should not oppose or withhold bail of accused on the ground of seriousness of offence. Let's further dig into the facts of the present case. The present appeal arises from order of Honorable High Court of Bombay, thereby rejecting the bail to the present appellant. The facts of the case are that the appellant was arrested for possessing counterfeit Indian currency in the denomination of rupees 2000 and first information was reported under section 489B, 489C and 120B read with section 34 of Indian Penal Code. Further, the appellant was in jail and as an under trial prisoner for past 4 years. Till this date, the trial court has not even proceeded to frame charge, and the prosecution agency, that is NIA, intends to examine more than 80 witnesses. However, the court, the Honorable Supreme Court, while having regard to the case of Gudikanti Narsimalu and others versus public prosecutor reported in 1978, has discussed the object to keep a person in judicial custody pending trial or disposal of appeal, in which it has been held that bail is not to be withheld as a punishment, but that the requirements as to bail are merely to secure the attendance of the prisoner at the trial. Further, the Honorable Supreme Court in Gurbaksh Singh Sibba versus State of Punjab held that the object of bail is to secure the attendance of accused at the trial. In short, the Honorable Supreme Court has reiterated that the bail is provided for secure the attendance of accused during the course of trial, but it should not be withheld as punishment to the accused during the pendency of trial. Further, while citing different cases, the Honorable Apex Court has reiterated once again the importance of Satyendra Kumar Antil versus Central Bureau of Investigation, in which the Honorable Court has discussed prolonged incarceration and inordinate delay engaged the attention of court, which considered the correct approach towards the bail. And further, the Honorable Court has marked opinion under section 436A of Code of Criminal Procedure, in which it has held that the provision contained in section 436A of the code would apply to special acts also in the absence of any specific provision. In short, unless there is any specific provision that section 436A of Code of Criminal Procedure would not apply, it would apply in all over provisions or any act unless they are specifically stated to be not to be applied. Further, the Honorable Court, observing in paragraph 19, 20 and 21, has held that if the state or any prosecuting agency including the court concerned has no withal to provide or protect the fundamental right of an accused to have a speedy trial as enriched under Article 21 of Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that the crime committed is serious. Article 21 of Constitution applies irrespective of nature of crime. We may hasten to add that petitioner is still an accused, not a convict. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, however stringent the penal law may be.